Hello, hello. Welcome back to Bring the Jury. We have been on a bit of a hiatus, doing like lawyer things in life. I'm doing life, they do the lawyer things. But we are back. I'm here with Luke and Bryan Sheely of the Sheely Law Firm, located in South Carolina, offices in Charleston and Columbia. My name is Hannah, and today we are going to discuss, we've got some good stuff for you guys today. We're going to talk first about some updates with Bryan Kohberger, and then we're going to dive into some nighttime tales from Luke. We're going to have story time with Luke. He's going to tuck you in with a nice little bedtime story from a good friend that he's made recently, who has some pretty good stories about serial killing.
Some insight into that line of work.
Yeah.
It's not really a line of work. It's really more of a lifestyle.
Yeah, it's a passion project that he has. So, Bryan, I'm going to pass it right off to you. We're just going to go ahead and get started. What is going on with Kobe?
Kobe. Bryan Kohberger, the little case that you may have heard of. So, this is the student killing of four that the nation is captivated by. And, he's represented by a very competent public defender and Taylor. There's been lots of evidence and motions and accusations flying around. The state has brought in, as we covered on some of our prior podcasts, a really crack kind of death penalty prosecution team. They've got the best of the best in the area. The answer to whether or not this is going to be a death case have been answered. They're going for it. And so we've spent a lot of time, there's been a lot of kind of struggles over evidence and discovery. A lot of that's been sorted out. But where we are most recently is that Ann Taylor, Bryan Kohberger's lawyers filed a pretty extensive, most of her motions seem to be fairly, extensive. They're factually pretty good. They're, she's, this is kind of lawyer that not only is thinking about what's going to happen in trial, but Luke, like any person defending a death penalty case, and you've done a number, she's building a record, because if he does get, a death sentence after a guilty conviction, it's all about the record and the appeals process. So recently she's filed a motion to dismiss that was denied by Judge. I love our judge in this case, the assigned judge. And the basis for her motions were basically grand jury malfeasance, the prosecution hiding the ball to the grand jury, which is kind of funny because in South Carolina, the grand juries are a secret proceeding. We don't even get invited.
Most of them are.
Most of them. But bottom line, Judge denied that pretty out of hand. But, again, the lawyers are filing records to preserve the appellate record. So the next thing that's kind of on the table is, the defense team has filed a motion to change venue. Luke, you filed a motion to change venue. What is that about, and why would the defense team want to do that in this case?
Well, it's all about a concern about not being able to get a fair trial in your particular jurisdiction, which might be small town Moscow, Idaho. This case has national, has international press. But really, when it's local like that, the whole community is affected by the college, by people that went to class with these victims. They're living it, they're breathing it. So again, it's one of those things to help protect the record. But honestly, as a lawyer, you sometimes feel that there's so much overwhelming publicity. Look at us, we're in South Carolina talking about it, that you do feel that you would have more of a fair shot at a fair and impartial juror, let's say, in a different county. I had a death case in Aiken, South Carolina, many years ago, and it was a police officer shooting case, and we filed the same motion because it was just so ingrained in that small town. It was so steeped that you couldn't really find anybody that didn't know about it. And of course, the prosecutors generally want to keep the case right where it is.
Why?
Because
why is that?
The facts are so salacious. If you're a prosecutor, honestly, you want that juror that's made up his mind that Luke's client is a guilty murderer and needs to go down for this. And so you want him emotionally invested for the wrong reasons. And that's just the honest truth. So you don't mind if it stays right there and you can whip up a modern day kind of lynch mob. And so, but sometimes you do have to be careful what you ask for. I mean, in my case, I think we asked for the change of venue, and it's kind of a hard standard. You really have to show why you can't get a fair and impartial jury. It's better if you have some data on it. Like you might have already sent out a jury questionnaire and they're all coming back, hey,
Luke, what's a jury questionnaire for a death penalty case? What do you mean?
Well, in a death case, well, at least in South Carolina, I don't know exactly how it works 100% in Idaho, but in South Carolina, you usually don't get in a state criminal trial a lot of time to learn about your jurors. But when it is a death case, you send out pre-approved, sometimes spot over questions to prospective jurors to figure out their views on a lot of stuff. Views on the death penalty, views on this particular case, what have they heard? Do they have preformed opinions? Because jury selection is where this case is won or lost. And so then they return their questionnaires and you have to really go through them. And there might be, that if you've got data that every single one of them has heard about this case, and let's say 70% of them are just like, no, I can't be fair and impartial. Then you go to your judge and say, look, I really need to change of venue. It might be that in the county over, they aren't it's not so ingrained in them. And so but a case of this magnitude, the county over, they may just as well know as much, but maybe 3 counties over they want. But you also have to think about kind of your demographics and what's the makeup of that county. And maybe there's not a lot of change in Idaho in the demographics, but in South Carolina, there's a lot of change in demographic from, let's say, Aiken to Orangeburg or Charleston to Greenville. And so it does, honestly, you're trying to pick a better place to have this play out, but it is a pretty high burden. And in our case, I think the judge toyed with the idea of sending it to Lexington County, which is probably the most conservative kind of pro-law enforcement county in the state. And so at the end of the day, he denied the motion. So sometimes you have to be careful what you wish for. And of course, the prosecutors, I think, in their response were like, you could go anywhere in the world and you're not going to find anybody that doesn't know about this case, Judge. It's just the citizens of Moscow have a right to keep it here.
Well, it's pretty interesting because, what you'll normally get is that the prosecution knows that they would like to keep it where the killings occur because they know it's going to be especially in a smaller community, it's going to be in the heart and minds of every person. Mm-hmm. Everybody knows somebody that knows someone that was killed in this case, or potentially could be a jury, or heard a story about one of the victims that used to go shopping at this shop. And so, but Luke, I want to bring to your attention something I felt, so of course they say what you suggested, the prosecutors, certainly they kind of puff up the local community. A local jury can be fair and impartial and can see past any kind of inflammatory nature of the crime itself. Here's something I haven't really heard before, though. Tell me, Hannah, your take on this. So the prosecutors, one of their main arguments is, listen, I think we got to keep it local because they're going to be more inclined to seek the truth and be fair-minded to get this thing right. Because when you're talking about a brutal murder, here's a quote, that means that if they don't get it right, the real killer could still be out there.
Oh my God.
So that's an interesting take from a prosecutor, that the jury potential panel would be more interested in being fair-minded because they want to get it right. You've got a background in human nature and counseling and psychology. What do you think about that?
It's so funny that you say that, because as you were reading that, immediately what came to mind. So when you're in like a counseling session, and it's been a while since I've been in a counseling session as a counselor, but you have to really be careful about asking leading questions because you're dealing with someone's mental health, and like they need to kind of arrive at their own time and have their own like opinions or perspective, thoughts, emotions. That statement is so leading, and like it's like just filling people with this preconceived notion. Like it's creating their own idea for them of like, well, if you get it wrong, like now blood's on your hands if this ever happens again. I don't know. It's just, it seems so
And you're right on that. And that is an argument. It's a very clever, silver-tongued argument by an experienced prosecutor to convince a judge to keep it, because, I mean, the pretrial publicity is not like, did he do it? It's just like, he did it, the DNA. I mean, they filed an alibi notice motion, but in it, it's like, it's not like, it's just like, I'm driving around all night. It's not like, hey, he was at this particular truck stop. So what's been infecting the public sphere is that he did it. He's creepy. He's got these eyebrows. He's criminology.
He's got the look, Maybelline.
You know, he's got the look.
I don't even know.
And, you know, when you get into the second phase of a trial, so the first phase of a death trial is guilt or not, and you know, it's interesting to see how that plays out. In most cases that are death end up not, the evidence is so overwhelming, you end up not winning on the guilt part, but where you can win is on what the penalty will be. But then that's where a smart prosecutor will prey on the hearts and minds and be like, look, you know, you're not safe out there. And there will be very little discussion of who the real killer could be. So it's clever, it's disingenuous. I don't know of any. Now, for all we know, there could be some very tight-lipped gag order, third-party guilt evidence of who the real killers could be, but unless that's a feature of the defense, if they're just simply only able to credibly say he wasn't present, he was driving around all night, and not supply a new set of suspects, then that argument doesn't really fly.
And I mean, your friend who has experience with killing people.
We're gonna get to that.
Would say, I'm biting at the. But
Anna wants to talk about new friends.
I do want to talk. We're not going to talk about it right now, but just as a teaser to keep you hooked, you said that he doesn't believe that Bryan Kohberger did it.
No, he doesn't.
No, so we'll get to that.
One of the few people in the nation that doesn't think that Kobe did it.
He knows one when he sees one.
So scheduling a death penalty trial is complex. It requires, you know, it's not even your average murder trial could be a week or maybe more. You know, death penalty trials, because of the guilt phase and the penalty phase, and, you know, the literal aspect of someone being sentenced to death potentially as the ultimate consequence for a guilty verdict. You know, there's experts, it's just a massive kind of undertaking. So you often will see the state not seek death unless they know they can get it, or it's so big of a case they can't not seek death. So we've had some scheduling battles also in the news recently on this case. And, you know, we're talking about savvy prosecutors and kind of the local, like, you know, they'll get it right because they can't afford to fail, because there could be a killer out there. Are there any killings happening in the area? So this is such a university town. It's a university community. The university is everything. I mean, they're trying to schedule this trial, and, you know, the defense are saying, you know, judge, we need 16 weeks to do this trial. Luke, is that about fair for a death penalty case? I mean, you've done death penalty cases where you're just picking a jury, and that's lasted multiple weeks, right?
Right. I think that's fair in a case like this, and half the time could be spent on picking a jury, because it is such an involved process to get folks that are fair and impartial, and you get individual sequestered voir dire. You get an opportunity to really work with individual jurors to reveal their biases or not. So there's a lot of ways to remove jurors for not being fair and impartial, and there you can get them stricken for cause by basically getting them to reveal their bias and say that they had a, you know, preconceived notion about him, or that they think folks should get the death penalty because it saves money, or that, you know, certain class of people or allegations are automatically going to be death penalty in their mind. And guess what? If you keep removing jurors for basically being statutorily barred from serving on a death case. And as far as a defense lawyer is concerned, if you don't have any jurors, then you don't have a death trial. And if you don't have a death trial, then the client's not getting executed. So it's a very in-depth, involved process. And then, you know, between all of the interesting DNA in this case and everything else and the 7-day manhunt, I think there's a lot of just reporting officers, forensics.
Well, here's what the state is trying to basically say, judge, we'd like to try this summer because we just don't want to try the case during the college school year. So again, about the kind of community feel of this, they're essentially not only we have 4 victims here, but they're almost saying the university is a victim. We don't want to traumatize the students. So we can't try the case during the school year. So the school year nowadays is almost the entire year. Mm-hmm. So we're saying, judge, let's go ahead and get this knocked out in the summer. We can't have the students go through this, which I get, but it also kind of goes to show the mindset that there's community outrage. I would be looking at that and saying, listen, we know we can't get a fair trial in the community if we can't, which is a university community, if we can't try the case when they're in school in the community. So that, point. And so the defendant, go ahead, Luke.
Well, I was just going to say, I mean, they want to be aligned with the school, but also logistically, if you get into a penalty phase, let's say that he's been found guilty of murder and then it's what sentence, you know, the prosecution is putting up evidence and aggravation. They're putting up victims. They get to talk about what a bad guy he is. And they also get to bring friends, colleagues, teachers, you know, all that stuff. So it could be that there are logistically a lot of witnesses whose schedules will be easier if they weren't in school. And then vice versa, you know, the defense is going to put up tons of mitigation, which is, again, any reason to spare his life. It could be his mom, his criminology professor that thought he was the best student, you know, guidance counselor from middle school that shared a moment with him as a young man. So it's just a lot. So, and, you know, the defense is always going to be looking for more time because the defense can always be more ready. So
that's right. So the defense team is, speaking of being more ready, is like, well, okay, we get the fact that the state doesn't want to do it during the school year. Okay, we can't be ready this summer. We've got we're not sitting on our hands. We have lots of preparation and lots of investigation we've been doing, but we're more inclined to be ready next summer, 2025, people. And Judge in some of his commentary, he has not ruled on the schedule of it yet, but we're almost in March. So, you know, a couple months is pretty quick to set and then start a death penalty case. So he's already saying some things in some of his rulings, like, you know, this could go in 2025. So that would seem to be, I think we had a running bet about this case, Luke, about.
Bourbon or a new car or something like that.
And the original date was like less than a year. And I was like, no,
that's crazy,
There's
right?
no way that's happening. And I don't think you truly believed it would happen that quickly, but I think we did agree to have a bet. So I think give him a bourbon.
Well, there was earlier in the case, I guess in the early fall of last year, Ann Taylor, her posture was very much push. And that has now changed dramatically. I don't know if that's because of the kind of death penalty aspect. I mean, you would assume she would prepare it all along, knowing that's going to be a death case. But remember, it felt like a game of chicken for a while there. She was very much, you know, basically had it in fifth gear and was speeding towards the destination. And they were coming, and someone bucked. I think it's safe to say Ann maybe was in the ditch at the end of that, and now she's backed off and is looking at 2025. So maybe I owe you something.
Yeah, I'll take it.
Owe you a drink.
No, a bottle of bourbon.
So there's been tons of discovery, pushback, and fighting. Luke, part of what the defense team is looking for in this case, and this is a case, we've got a horrific murder. And there's DNA on a sheath of a knife that was used in this murder. Mm-hmm. That's got Mr. Kohberger's got touch DNA on it. And so DNA is a huge part of this case, but the DNA itself is going to be a really novel issue. Don't you hate that? Defense lawyers hate that. Oh, great. We've got a body of forensic science that's going to be novel. Our old boss, Doug Strickler, back in the day, so like in the early 90s, in the capital of South Carolina, he was the chief public defender, and he would tell the stories that when DNA was making its way to Columbia, South Carolina, and, you know, peer-reviewed science, great technique. And he was like telling juries that take that jump back to New York City to the jurors. And they were like, okay, well, we get it. But like DNA is
Witchcraft.
yeah, take that voodoo. But in this case, we've got DNA is incredible type of evidence. We've dealt with it in many of our cases. Why is this DNA different, Luke?
Well, it seems to be that the main lead was through this IgG DNA database. It's genealogy.
Is that investigative genetic genealogy?
Yes. This is kind of secret FBI database where they seem to get some of their profiles from volunteer DNA, things like Ancestry.com, 23andMe. Because whenever you get a sample, you want to
Be careful if you do one of those.
Oh, yeah.
Oh, that's why I haven't done one of those. The fine print says that the government can use it. Plus, I don't want to know about all the other brothers and sisters I have out there. But
Just this one.
but usually, and if you're a police agency and you're dealing with a known criminal who has been forced to provide a sample due to prior arrest or a prior conviction, it's nice. Then you have this nice database nationwide called CODIS, and it can ping and go, okay, you got a match of this percentage, but then so that gives you a probable cause to go search for this guy or to investigate further, and then you can do your trash pulls, or you can just arrest and get a warrant and get a buccal swab, and then you have a nice fresh sample to compare in your lab for trial purposes. But this, they had a car, they didn't have, you've got this bloody, gruesome murder with, really nothing going on except neighbors hearing a dog bark. You've got Kohberger, who looks creepy, but, people got arrested for the way they look, then, clearly none of us would be arrested, but
No.
but there'd be a lot of people in trouble out there. And so in their original affidavit, they talk about all their investigative techniques and matching cars, but there's always those questions like, well, what about all the other cars that generally would have matched this Hyundai Elantra from this year?
It's like the most common car.
Right. How did they, we always on earlier episodes were like, well, how did they rule in or rule out folks? Well, it looks like they had a little help from, 23andMe and things like that. This very closeted, secret lead that they got that said, we think it could be Kohberger. So then they went running out to his family's house, did a trash pull, got an actual normal scientific technique, Y chromosome, male member match. And then that gave them the juice they needed to get, arrest warrants and search warrants and all of that. So,
and they found a bunch of things
right.
that Luke also has in his house.
Right.
Ski masks, guns, knives.
Right. All the stuff that, I got, half of that's in my car right now. And so the defense is really zeroing in on this kind of novel way of matching folks that the feds don't want to disclose, the state prosecutor doesn't want to disclose. And, whether it's right or wrong, whether we as defense lawyers like novel techniques in our case, I don't know. It's kind of a double-edged sword. On the one hand, if it's novel, then we don't have the best way to confront it in real time. But you can also do what our old boss said, take that government science back to 23andMe,
which works really well in South Carolina.
It plays. It does play. And so I think there's right now an ongoing battle about revealing those techniques.
Well, just recently, Judge John has, as judges like to do, kind of split the baby and has ordered the FBI to turn over some of their IgG information to the defense, probably things that are very specific to what led them to Kobe. So it, it's under a gag order, all this kind of stuff. So like no one really knows exactly what was turned over, but we do know that some information has been, after this hard fought battle, which has really been going on the entire time, the defense gets some information. So that'll be helpful, but
We could make a novel legal issue that helps them challenge something on appeal.
So speaking of novel, it's not every day that you get to make friends with a serial killer.
I thought when you said novel, you were going to mention Becky Hill's new book.
But you got another one?
No.
So Luke, you had an opportunity today to speak to a notorious serial killer for an hour or so.
Yes, I did.
And Kobe came up,
Kobe came up.
amongst other things.
I'm not going to reveal the name of this serial killer. He would not describe himself as a serial killer, but I think objectively,
By definition.
the world has defined him as a serial killer. He would say that he just has a problem with conflict resolution.
That's what he did say. Just conflict. I just got a problem with conflict resolution.
But I am representing him on some minor matter pertaining to the aftermath of his case. But we're getting to know each other and we're talking, and he's actually really interesting, personable guy, and he does have a bit of a fan base, and there's lots of true crime interest in him. But so somehow, one or another way, he brought up maybe this case, and so he was giving me his kind of take, his kind of professional assessment of the evidence in this case, and I found it pretty interesting, and he was pretty insightful. And some of the stuff that we've kind of touched on, you've got this heinous crime that was done with a knife, so it's pretty rare in that it's a close quarter situation, and my client has some experience with those close quarter victim situations, and he, his insight was essentially that, people are going to be fighting for their lives, that they're going to be making noise. It's going to be extremely messy. And so he has a lot of questions about the evidence in this case, and that he believes that it would be very unlikely for one person to go room by room, kill 4 students, to the point where they're unaware that there wouldn't be any serious wounds and scratches to Mr. Kohberger. Again, they're fighting for their lives.
That's what we've always said, and we've always believed that. And he also of course, he's got lots to say about touch DNA, and it's just ridiculous. And again, I think there were some prior episodes we were discussing this IgG, and there were some motions relating to contamination. When you get the sheath of this knife and you're examining that and you're trying to compare, is there the potential for contamination where maybe you're sent something from an IgG lab? I don't know how they analyze things. Is there potential to contaminate the actual sheath? Touch DNA is, you touch, it can be transferred. It's very easy. So he had a lot of knowledge on that, but it was really interesting to hear him talk about, just from personal experience, the screams and the fighting that would be occurring. It's just, he finds it highly improbable. So that one person could have done that alone, without waking up the whole world and having just be drenched in blood. And
so who is he interested in knowing more about? What are their names?
Well, he thinks it could have been either, quote, an inside job, which I don't know about that, but there are some folks that I think were, isn't there? There was we had a prior episode about the DoorDash driver who ended up.
Brian said it looks like me.
Yeah, looks a lot like you. Not very flattering picture of.
That's what my husband Tim gets at 6 a.m.
Yeah.
So sweet.
So our guy, number one, doesn't think, due to the intimate nature of that killing, that it could have been done so cleanly. Is that what he's saying? Or
He thinks it would be very messy. and that you'd have a lot of wounds and there'd be a lot of blood, trace evidence, contamination.
So when he's saying wounds, he means to the assailant would be injured pretty good.
Right, because the victims are fighting for their lives.
Right.
And as far as we've covered this case, yes, they didn't get to Kohberger until a little bit later, but there wasn't blood transfer, there wasn't wounds, cuts, black eyes, DNA under fingernails, things of that nature.
And didn't he mention that he certainly believes this was more than one person that did this?
He thinks it would have to be more than one person to.
Why?
Because if you're killing one person, you're going to be waking up others, and they're going to be fleeing for their lives, or there's just he thinks.
And there were 6 people in the house, right?
Yeah.
6.
I think total, right, with the 2 living witnesses. And he just thinks that you would need multiple assailants at one time to accomplish it in the way it was done. So he doesn't think it was a one-person job, and that's coming from an expert, let's just say.
And he thinks also maybe somebody that had intimate knowledge of the group, like an inside situation, right?
Yes, he thought it could be an inside job.
And he's been thinking a lot about this case because he's doing multiple life sentences and he's got nothing else to do, right?
Well, he's got a lot of time on his hands, and he does have a bit of a following. So I think he engages or has engaged in kind of true crime analysis quite regularly from his fan base.
Wow.
Just like us.
Just like us. So it was a fascinating conversation, and that's all I won't say anymore, but it was interesting to get the insight from someone who, even though it's maybe grotesque in some people's minds, has literally been in the shoes of that type of killer and can kind of give like a first person perspective on it.
So Luke, if this case, which I think you probably agree, likely gets pushed until the summer of 2025, what is happening in over a year? What's the defense team doing right now? What's the state doing right now?
Everything they can. I think the defense is trying to battle this DNA so hard. I guarantee they've got DNA experts on hand, and they can really have a full opinion if they get pretty much everything they need to attack the IgG. If there's ways for contamination to occur, or if there's something about the way someone might submit their DNA in the mail for 23andMe, there's no you just send it in voluntarily and say, I want to learn about my ancestry, but there's no, as far as I know, concrete verification, photo taking at the time of sample. It could be anybody. So is there a challenge to wherever they even got the Kohberger DNA that was actually Kohberger, or was it someone else? So that you want to be able to attack that. You're spending all your time preparing that. And
a massive third-party guilt investigation?
You would
think
think
lots of time.
We were part of a team that had a double murder case in South Carolina that was a death case. And I can't take full credit at all for it, but the other attorney, who was the lead attorney, he basically, in order to get the case dismissed, had to solve it for the prosecutor. And he through our investigation, pretty much figured out who did the crime and put it right on the lap of the prosecutor. And then, now, as far as I know, they never arrested anybody else, but it was so overwhelming that they dismissed our client's case. And by the way, we need to talk about that because they're running stories about her in the news.
I heard about that.
So you can, if your jurors are normal folks, they want to
investigating people that, maybe are getting in trouble.
Reasonable doubt is one thing, but jurors are watching true crime, they're watching documentaries. If they want to, it's hard to say that they will hold themselves to the perfect standard of proof in a criminal case. It's a lot easier if they have some doubt because they think someone else did it.
Yeah.
They really do. But as a defense lawyer, you can't just throw mud on the wall and say, hey, so-and-so might have been in the area and I think they're bad. You have to connect the dots.
And The other thing I think about, excuse me, death penalty cases is the ultimate up in the ante, leverage point. The prosecutor's basically saying, listen, you're going to die at the end of the conviction. We're seeking death. There's no games here. You're eligible. And, we have a lot of death penalty lawyer friends that's all they do. Luke, you've worked on a number of them. And I think it's safe to say on your average death penalty case, a good result is pleading to a life sentence. That is a really good result on a death case because you're not getting the chair, not getting the firing squad, not getting a needle. And I think most death penalty advocates say, yeah, that's kind of what we're looking for, to take that terrible, terrible penalty off the table. I mean, there's no chance, doesn't seem to me, Luke, and I'd love to have your take. I don't think that Ann Taylor is looking for a plea deal, even if she could get one on this case, to take death off the table. I mean, you think it's likely that all of a sudden we're going to have a guilty plea to a life sentence on this situation?
It's hard to say without evidence, me knowing all the evidence, but politically speaking, I mean, that's why the prosecutor is seeking death. It's heinous, it's local, it's terrible. It's not like some prostitute who was the lowest of the low ended up dead. I mean, these are, college students in the prime of their lives who are very squeaky clean, shiny, sympathetic victims. So politically, they want to seek death. There's been some posturing from the defense that at least publicly makes it seem like they're pretty confident in their case. So it's just about where the rubber meets the road. But as a death penalty lawyer, you always are looking for that back door of a life sentence, because there's nothing worse than losing the case and having your client go to death row. So you're always working it hard. And part of it is a flex. It's, you make the other side concerned because politically it's advantageous to seek death, but it also sucks if you lose your death case, because then, the local community is unhappy with you and you might not win your next election for DA, or the sheriff might lose because his department looked bad. So it's definitely a political calculus, but I always want to have my client prepared. And sometimes the client can be a real problem. I don't know anything about Mr. Kohberger, but sometimes some clients really, they don't contest it. They want their life sentence. They're scared of what a death trial would do to their family, or they're honestly scared of dying. Sometimes the client is not reasonable at all, and they want it regardless of the odds. They might have a life offer that they've turned down for a year. So it's very client and fact specific, but at some point the rubber meets the road and things can shake loose either way.
Well, we got some new friends, so maybe we'll have further insight into Kohberger and any other cases that we end up discussing here on this podcast.
I think that'll be a great take. This has been wonderful just to get back in front of you guys. And if you're listening to this later in the week, then I guess through your speaker. Please always keep in mind that you can always, it's a two-way conversation. If you have cases that you're interested in knowing more about, or want us to talk about, you can always send those to us, and we're happy to discuss them on YouTube Live, or if you listen to this later. But yeah, we've got lots to uncover with Kobe and perhaps these two here. So looking forward to anything that kind of comes to light that
Your
we can all talk.
cousin.
Yeah, my cousin Emma. Not funny. But yeah, thank you guys so much for tuning in, and we will see you all next week. This has been
Bringing the jury.
And I forget how to turn this on. It's been so long.
There you go.
There we go. And Jesselyn, thanks so much for tuning in live and asking some great questions. Sorry we didn't get to those tonight, but we will definitely take a look at some of your questions and keep those in mind for our next stream.